Violation of restrictions on a permit on a first conviction shall not exceed $250, and the court shall suspend a person's privilege to operate a motor vehicle for not less than 30 days or more than 2 years. It goes on to talk about second or subsequent convictions, but this is not charged as anything but a first. So it looks like if you're found guilty either by a plea of guilty, no contest, or at trial, you shall be given a fine up to $250, but no more than, and you shall get your license suspended for at least 30 days, but no more than 2 years. All right, so for first conviction, doesn't talk about jail time, so I can't appoint an attorney to represent you, but you can hire an attorney. Do you want some time to hire an attorney, or do you wish to waive your attorney and represent yourself? Mr. Gaddy?
I will just represent myself, Your Honor.
And Your Honor?
Yes, Mr. Regier?
The court did appear to refer to certain sentencing provisions under KSA 8291. The state understands that count 2 is charged under KSA 8245, and pursuant to subsection D of the same, quote, it is a misdemeanor for any person to operate a motor vehicle in any manner in violation of the restrictions imposed in a restricted driver's license issued to such person.
But there's a specific sentencing statute in 8291 for violation of restrictions on a driver's license or permit, and when you have two statutes in contradiction, as that would appear to be, then the more specific applies, and that's why I picked 8291. Now, if we went with the statute itself that says penalties, you shall be guilty of a misdemeanor, then you shall not be fined more than $500, nor sentenced to a jail period more than 90 days, or both. But that's 90 days would still be less than the 6 months that case law talks about appointing an attorney if jail time is over 6 months, 6 months. So I can give you time to pay an attorney if you want to go out and look for an attorney, or I can accept your waiver at this time if you want me to proceed today. Sir, how would you like to proceed, Mr. Gaddy? Do you want time to talk to an attorney, or do you want to proceed today?
I will just proceed today.
All right. Well, in order for you to do that, I need to know that you understand you do have the right to go out and hire an attorney if you wish to. Do you understand that?
Yeah, I might as well do that.
All
That
right.
way I don't.
Okay.
It would just make all this easier.
All right. So let's set this over to a Monday morning at 8 a.m., please, Destiny.
Yes, Your Honor, that'll be November 10th.
All right, I'm going to continue this so you can talk to an attorney to November 10th and be back here at 9 a.m. with that attorney ready to go should you choose one. If you don't wish to choose or hire an attorney after you've talked to one, then be sure and be here ready to go at that time. All right, and is there I don't know if there's any chance this is a divertible offense that you could talk to the county attorney about diversion. They usually want you to go and look at their website online. So,
Okay.
Deputy, if you have that website, he can look at it and see about diversion too.
Okay.
So please put in the docket notes on the record, he's going to look into diversion and look into hiring an attorney. All right, and you're going to have to be back here. Are you on bond?
He needs to go get processed, Judge.
Yeah, go out and get your picture and prints taken, and I'm gonna give you a $500 cash or surety bond.
Cash or surety?
Cash or surety on $500, yes.
Ooh.
All right, if there's nothing further, we'll be in recess on Mr. Gaddy.
Do we need to take him into custody?
I don't believe so.
Okay, well, then you'll have to post his bond out at the jail of $500 cash or surety.
Right.
Okay,
Make sure you don't violate any more laws, sir. You'll get worse problems.
Understandable. The $500, do I need to pay that?
You'll pay that at the jail, either in cash or have a bondsman help you post it.
Would I not have to pay that if I just continued today?
Well, I am continuing it,
Okay, understandable.
and you would have to get your picture and prints taken. Now, if we didn't continue it and we resolved it today, you'd have to get your picture and prints taken, but you wouldn't have to pay the bond, no,
Okay.
because your case would be resolved today.
I apologize. Can I just resolve it today? I understand that.
Well, I don't
Okay.
want you to feel pressured into giving up your right to an attorney, Mr. Gaddy.
Okay.
I'll tell you what,
Understand.
I'll make that an OR bond, deputy. Make it OR since he did come in on his summons.
okay.
I don't want to give him the impression that he has to waive his attorney today.
Thank you, Your Honor.
You're welcome. Fill out an application if you, well, go hire your attorney, because like I said, I don't believe I can, with these penalties, I don't think I can appoint an attorney.
Understandable.
Okay. While you two are finishing up, there's a William Alexander, how do you pronounce that last name? Acevedo? Acevedo, how do you pronounce that, sir?
Good morning, Your Honor. Acevedo.
Say that again, please.
Acevedo.
Acevedo, okay.
That hearing had a little bit of everything. Judge Webster presided over the case of Marshall Gaddy, and what might have been a simple traffic violation turned into a careful discussion about statutes, penalties, and the right to an attorney cited for speeding and for driving without the corrective lenses required on his license. Judge Webster walked through the statutes, noting that one provision suggested a license restriction violation was punishable by a fine and a mandatory suspension of driving privileges for 30 days to 2 years, while another statute described it as a misdemeanor carrying up to 90 days in jail. The back and forth with the prosecutor clarified that under either statute, the maximum jail exposure was less than 6 months, so the court couldn't appoint an attorney at public expense, though Gaddy could certainly hire one. When asked how he wanted to proceed, Gaddy initially said he'd represent himself, but then decided he'd rather have time to consult an attorney. Judge Webster agreed, continuing the case to November 10th and encouraging him to look into whether the charge might be eligible for diversion. He was also ordered to get processed at the jail for photos and fingerprints, with bond initially set at $500 cash or surety. Sensing Gaddy's confusion about whether he'd have to pay that to remain free, Judge Webster modified it to an OR bond, noting he didn't want Gaddy to feel pressured into waiving his right to counsel just to avoid paying. Gaddy was polite and respectful throughout, candidly admitting he'd rather get the matter resolved quickly, but not at the cost of giving up his right to talk to a lawyer. The courtroom tone was calm, procedural, and even lightly instructional, with Judge Webster threading the needle between efficiency and fairness, keeping the case on track while reminding the defendant that rushing isn't always in his best interest. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.